Yes, Mr. McGill.
Lord, can I return to the query of Lord Toulson, having directed our attention to particularly Section 44 of the Serious Crime Act of 2007. I'm conscious of the fact that it's not in the bundle.
Well, Lord Toulson kindly supplied us all with it.
And that will do, because the rest of us have got other means of finding it. In addition to the point of distinction that I mentioned before lunch, there are other, seems to the respondent, two other essential differences between the Section 44 situation and this type of liability, parasitic accessory. As is apparent, because it's an inchoate offence, the consequential offence that the defendant commits under Section 44 or Section 45 doesn't have to be committed. The offence is the defendant's own offence of doing an act capable of encouraging or assisting the commission of the consequential offence with the necessary intent, Section 44, or the necessary belief, Section 45. Whereas, of course, parasitic accessory liability does not get off the ground. There won't be a count on the indictment unless, in that situation, the act of the defendant, the secondary party on trial, has been proved to have assisted or encouraged the principal's commission of crime B. And of course, that will always be a fact. That will have occurred. The principal will have committed the consequential offence, and the prosecution will have to prove that there was a link, a connection between the act of the secondary party and the commission of crime B by the principal. The second, it may be thought, point of distinction is that Section 44 addresses, in Section 44(2), the foreseeable consequences of the defendant's own act. And his own act, which is the subject matter of Section 44, is of course something over which he has control. It's his own deliberate act. Parasitic accessory liability addresses the defendant's foresight of the act of another person, over which, of course, he may not have control. He will not know, does not necessarily know, that the principal will commit the principal's act, but the basis of the principle of liability is that the defendant, the secondary party, is prepared to take the risk that the principal will commit the principal's own act, and despite that awareness, he, the defendant, deliberately commits his own actus reus for crime B, that is, his own act of assistance and encouragement, which in fact links to the commission of the crime by P, that link.
But I'm not sure that's a real point, is it? Isn't the distinction you draw between his act, the defendant's act, and the other person's act, because isn't the very point that subsection 2 is concerned with, is the foreseeable consequences of his act in producing an encouragement or assistance to the defendant in committing an offence?
Well, I'm not so sure. You're saying, I think, that the Section 44(2) addresses not the foresight of the ultimate offence by somebody else, but the effect of encouragement or assistance.
Yes, of his own.
Towards it.
Yes.
Does it?
Yes.
But it's what is not enough to establish the mental ingredient is the foresight that this will encourage or assist the person, isn't it? It's not enough merely because the encouragement or assistance is a foreseeable consequence of his act. In other words, it's insufficient for him to realise, be aware that this is this may well indeed assist and encourage the other person in the commission of offence.
But awareness that his own act will encourage the other person to commit what I call the consequential offence.
Right.
So it's foresight of the consequences of his own act.
On the other person.
On the other person.
Precisely.
Whereas the foresight test in parasitic accessory liability is foresight not of the consequences of his own act that's in issue, but foresight of the act of the other person.
Mm-hmm.
But you might think, mightn't you, that foresight of the consequences of your own act was more heinous than foresight of the possible consequences of somebody else's act.
Save that, as I've indicated, you are liable under Section 44 whether or not there is a consequential offence committed by the person you have assisted or encouraged, whereas in practical terms, in real terms, when one's looking at parasitic accessory liability, the starting point is, on a trial with a jury, that the principal has committed the act that you as the secondary party foresaw he might commit. And that's why we say it does require you to take a long, hard look, I agree, at these provisions and compare them to the concept of PAL, that you can't necessarily read across, and they don't, these provisions don't necessarily provide an argument against parasitic accessory liability. We understand that these sections 44, 45 and 46 have been considered by the Court of Appeal Criminal Division in Siddiqui and Hussain. We haven't got them, we're only looking at the head note over...
Lord Justice Hooper's case.
Lord Justice?
Hooper.
Hooper? I think it was.
It was largely on the offence. If so, it was largely on whichever of these offences it is, which deals with encouragement and the consequence of multiple.
Yes, that's section 46.
That's right.
Whereas we understand from the head note, it would appear that the purpose, according to the Court of Appeal in Siddiqui and Hussain, I think number 2, because there was a second attempt to get it right in that case. We understand that the court said that the purpose of section 46 was to provide for the relatively common case where a defendant contemplates that one of a variety of offences might be committed as a result of his encouragement or assistance. We understand that the word contemplate at least appears in the head note, but I'm afraid we can't take it any further than that. Lords and Ladies, I was going to take you through, having dealt with Chan Wing Sui, I was going to take you through Hui Chi Ming, but I know that Mr. Knowles has taken you through the detail of that, and the only 2 points of any substance that emerge from Hui Chi Ming, which is at Authorities Bundle 1, Tab 6, Electronic Bundle Number B117, has already been referred to by Mr. Knowles, and the second point that was in issue there, that is the extent to which there has to be contemplation by the principal as well as contemplation by the defendant, the secondary party who's on trial. Lords, in fact, the Privy Council had little difficulty in saying that on the facts there must have been there was ample evidence that the principal had contemplated, because he'd pursued the victim in possession of the heavy piece of piping, and they went on in any event to hold, and this, we submit, makes practical sense. Again, you're looking at this working backwards from what's on the indictment. It is known that, for these purposes, in order for the secondary party to be guilty at all, it must be proved that the principal has committed the act of murder with the necessary intent. And if that has to be proved, it might be thought of only somewhat historical interest or relevance to spend much time on what it was that the principal contemplated before he actually committed the offence of murder with the requisite intent, and that the Privy Council held quite rightly that where there should be focus is on the subjective state of mind of the defendant who's on trial, his foresight. Otherwise, of course, as my lords know, Mr. Knowles having taken you through it.
Well, that's obviously right. I wondered if what counsel for Mr. Hui Chi Ming had been getting at was the proposition that you didn't only have to prove that R. Poe had the necessary murderous intent, because, as you say, by definition, he did. Leave aside the result of the first trial, but
yes.
By definition, for
yes.
purposes of this trial, he had. But what he was getting at was that there needed to be some sort of meeting of minds, some sort of concurrent contemplation at the same time,
yes,
rather than independently.
Yes, that would certainly make sense as far as crime A is concerned, because on the authorities, the principal and the person who ends up as a secondary party must have a common purpose to commit crime A. But if that is what counsel was submitting, then the Privy Council, we submit, rightly held that when you come on to crime B, this is really almost consistent with, do you plump for common purpose or do you plump for foresight? If you don't plump for common purpose, then it really doesn't matter a great deal to ask whether at any point in time, as far as crime B is concerned, the principal and the secondary party had or shared the same contemplation. So even if that's what counsel did mean, I suspect he would have got the same dusty response as the submission he made did.
Thank you.
My lords, then I was going to take you to, because it's an authority that was relied on by Lord Hutton in Powell and English, to the Australian case of McAuliffe and the Queen, which is at tab bundle 5 of the authorities, tab 92,
Page.
Electronic page 2390.
Thank you. Yeah.
And this was a case again of a joint venture, more than one defendant. The defendants, it was established on the evidence, had gone out looking for somebody to, in the local vernacular there, somebody to roll or to rob or to bash.
Yeah.
They came across somebody and they duly proceeded to roll, rob and bash. He fell down, or he was pushed down the side of a cliff and died from his injuries. And we can see in the report at bundle page 2394, third paragraph down, the prosecution put its case that the common purpose of all three youths was to rob or roll someone. It was, so the prosecution contended, expressly or tacitly part of that common purpose that the victim or victims would be attacked by one or more of the group with an intention to inflict grievous bodily harm, that is to say, serious bodily injury. Alternatively, the prosecution contended that each of the youths contemplated the intentional infliction of grievous bodily harm as a possible incident in carrying out a common purpose to assault someone. Prosecution further contended the common purpose was carried out and none of the three youths withdrew from it until after the victims had sustained their injuries, which the youths directly inflicted on them. And then towards the bottom of that page and over onto the next page, the court set out the direction that the judge gave to the jury, including, as we see at the bottom of 2394, they had to be satisfied that the defendant either shared the common intention of inflicting grievous bodily harm or contemplated the intentional infliction of grievous bodily harm by one or other of them was a possible incident in the common criminal enterprise. And then a little down the page, in the context after the citation, those directions convey to the jury that even if the common purpose of the three used did not embrace the intentional infliction of grievous bodily harm, there was a sufficient intent on the part of the appellant for the purposes of murder if he contemplated the intentional infliction of grievous bodily harm by one of the other participants as a possible incident in the carrying out of their joint enterprise and continue to participate in that enterprise. You can see from the next paragraph the appellants contended that the trial judge was wrong in giving those directions. We see from the final sentence of the paragraph the court said, in our view, that contention must be rejected. It then speaks of the common enterprise and says at the bottom of the page and over onto the next page, B2396, the liability which attaches to the traditional classifications of accessory before the fact and principal in the second degree may be enough to establish the guilt of a secondary party in the case of an accessory before the fact where that party counsels or procures the commission of the crime, and in the case of a principal in the second degree where that party being present at the scene aids or abets its commission. But the complicity of a secondary party may also be established by reason of a common purpose shared with the principal offender or with that offender and others. Such a common purpose arises when a person reaches an understanding or arrangement amounting to an agreement between that person and another or others that they will commit a crime. The understanding or arrangement need not be expressed and may be inferred from all the circumstances. If one or the other of the persons to the understanding or agreement does, or they do between them in accordance with the continuing understanding or arrangement, all those things which are necessary to constitute the crime, they're all equally guilty of the crime regardless of the part played by each in its commission. Not only that, but each of the parties to the arrangements or understanding is guilty of any other crime falling within the scope of the common purpose which is committed in carrying out that purpose. Initially, the test of what fell within the scope of the common purpose was determined objectively, so that liability was imposed for other crimes committed as a consequence of the commission of the crime, which was the primary object of the criminal venture, whether or not those other crimes were contemplated by the parties to that venture. However, in accordance with the emphasis which the law now places upon the actual state of mind of an accused person, the test has become a subjective one, and the scope of the common purpose is to be determined by what was contemplated by the parties sharing that purpose. And then there's then reference to the case of Johns. And that was a case, as I say, that Lord Hutton placed reliance upon in his speech in Powell and English.
The point, I think, which in a sense matters, is we go to the middle of page 115, the B2397, having cited from Johns about 8 lines below the break, they say, the court, that's the court in Johns, did not consider the situation in which the commission of an offence which lay outside the scope of the common purpose was nevertheless contemplated as a possibility in carrying out the enterprise by a party who continued to participate in with that knowledge. And then they go on to say, but that was considered by Chan Wang Su, and that's the answer. Yes. So this is not... They identify that the point which Chan Wang Su created was not a point dealt with in Johns, and they look to Chan Wang Su for the point,
yes,
and they follow it.
Yes. Well, it's obvious too that the court considered it in McAuliffe, as we can see from the earlier references, and did consider that the alternative way of putting it as something that was beyond the common purpose was acceptable. But it's there because, as I say, Lord Hutton referred to it in Powell and English. And Powell and English is really where I want to end, because really the point will be made, quite understandably, everything after Powell and English doesn't matter, because Powell and English made the position absolutely plain. And my lords, without taking you to it, because I'm conscious of the time, I was going to take you to what Lord Mustill said, the reference for his reservation. It's tab 137. I understand, my lady, now that over lunchtime the page numbers have been updated. I say that with some caution because this is hearsay evidence. I've been told that's what's
We've
happened.
been told it too, so at least
Well, it's
corroborative hearsay
it's
evidence.
tab 137. It's
3506.
It's B3506 for the beginning of the report, and Lord Mustill's speech, which I've summarised earlier, is to be found at page 3516. And I'm afraid I haven't got the electronic reference, so can I just draw up? Lord Hutton addressed the problem case that was referred to by Lord Mustill, thank you, at page 20 of the report, which is electronic bundle page.
32525.
Yes.
Yep.
And it's towards the top of 3525, having referred to what Lord Lane said in Wakeley and the reference to tacit agreement. He said just below letter B, nevertheless, it is possible that a case might arise where a party knows that another party to the common enterprise is carrying a deadly weapon and contemplates that he may use it in the course of the enterprise, but whilst making it clear to the other party that he's opposed to the weapon being used, nevertheless continues with the plan. In such a case, it would be unrealistic to say that if used, the weapon would be used with his tacit agreement. So they're addressing the issue that had caused Lord Mustill some concern by effectively saying that the foresight concept will do the job.
And he finds it in Wesley Smith and Macauliffe.
Yes, he does.
Again.
Okay, thank you.
Lords, that's where I want to end with Powell and English, because as I've indicated, any authority thereafter is really following Powell and English. And just a few minutes on the particular facts of the Jogee appeal. As I said, my lords, when I got to my feet this morning, the court now has the benefit, I don't know whether copies have been provided to you, of the transcript of the ruling of Mrs. Justice Dobbs on the half-time submission.
We had those.
It's dealt with, I think as printed, it runs to about 8 or 9 pages. The relevant parts start, if you've paginated them manually, from page 6, where there should be at the bottom of page 6 a paragraph that begins, "The Crown's evidence shows A." She summarises there what it was that the Crown's evidence showed. And then over the next page, annually numbered 7 by me, she sets out towards the top of that page what facts and inferences the Crown submitted at half-time flowed from the facts that she had referred to earlier. And the gist of her ruling is to be found on page number 8. She says, a little before halfway down, the question is there sufficient evidence on which a reasonable jury properly directed could convict? She goes on to say that she doesn't think that the prosecution's case had changed so fundamentally. Then going back to the question she asked herself, in my judgment there is, if there was no evidence of the former incident involving the knife in the kitchen, then the prosecution would have a problem. But given the knowledge of both defendants of the existence and availability of the knife in the kitchen, set against the other background evidence relied on by the Crown, it is open to the jury to find that Jogee realised that Hersey might use a knife intending to cause at least serious bodily harm and participated by encouragement, and that Hersey killed with the requisite intent. Whether they do is another matter, and the points raised by the defence are matters to which the jury will need to pay close attention. And there can be no doubt that Mrs. Justice Dobbs' direction to the jury was in conformity with the law as it currently is. I should say, for what it's worth, that it's apparent when one reads the transcript of the evidence of Naomi Reid, and I'll simply give my lords the relevant page numbers. They're electronic bundle pages A615 to 618 and A643 to 644, passages from her evidence in chief. It's apparent when you read those passages that the inference on the evidence was that the knife that Jogee had picked up during the earlier visit was the same knife that Hersey picked up during the later fatal visit. And again, not apparent perhaps from any of the cases, it's apparent from the summing up, the relevant references being bundle pages A549 through to 552, that although Jogee did not give evidence, as indeed neither did Hersey, he did admit in interview that he had seen to some extent what Hersey did, and it was apparent, or the inference could be drawn from what he told the police in his interview under caution, that he had seen Hersey in possession of the knife before the fatal wound was inflicted. And clearly, as a matter of legal logic, if there was sufficient evidence for Mrs. Justice Dobbs to reject the half-time submission of insufficient evidence, what then happened was that there was no evidence called on behalf of either defendant, and therefore, if her decision at half-time was correct, that the respondent would contend that the conviction that followed for Mr. Jogee was safe. Unless my lords or my lady have any questions.
Okay.
I should say that I do adopt the submissions that my learned friend Mr. Stevens has made on papers on the main point.
Thank you very much. Thank you very much, Mr. McGuinness. Mr. Atkinson. Mr. Stevens.
My lords, my lady, I'm going to start by addressing, if I may, the points which you have heard from, in respect of which you have heard from Mr. Knowles this morning. In other words, the two grounds on sentence,
Fine.
on the assumption that the law as hitherto understood remains the law.
You mean not on sentence?
Forgive me, on conviction. I'm then going to move on to the matter of greater substance that has occupied more of the court's time. Can I, briefly though, just dispose of the ground in relation to sentence, because we deal with it in paragraph 6 of our printed case at page 380, and our position is quite simple. We accept, on the authority of Ali and Tiwari and the state, that the appellant's sentence should run from the date of conviction.
Yeah.
I paraphrase, but that case deciding that it will only be in exceptional cases that any other order would be appropriate, and we don't so contend. My lords, with that, I move to the two grounds of appeal against conviction, with which we deal at paragraphs 27 to 36 of our printed case, pages 389 to 392.
Thank you.
And I will essentially be following the scheme in which we have addressed them in the printed case.
Yeah, you'll remember that we've read your written case. Thank you very much. Yeah.
My lord, I'm grateful. There are two grounds. The first obviously relates to misdirection in relation to joint enterprise, and the second, allegedly prejudicial hearsay. So far as the first ground is concerned, Mr. Knowles took you to the relevant passage of the summing up this morning, which, to remind you, begins at page 128 of the
Thank you.
record.
Yep.
And runs through, my lord, to page 131, which I would invite you just to turn up once more, I promise for the last time.
Yeah. Thank you.
My lord, it starts in earnest at the bottom of page 128 at line 24. I'm not going to reread it, but what I do say in my printed case and stand by with respect is that for the most part, the judge directed the jury in terms of, variously, a joint plan or agreement, common intention to commit the offence, I paraphrase, he uses slightly different terminology on different occasions, and moreover, subject of course to the point that my lady made this morning about possible ambiguity about what offence.
Which offence, yes.
Yes, well, I say possible, my lady, because I don't with respect accept in the circumstances that the jury would not have understood that this could only have been the offence with which he was charged, read in the context of the summing up.
No, I understand that.
My lady, that being my position, what we find between page 128, line 24, and page 130, line 14, is entirely directed to the commission of the offence murder. And it is a direction which is focused on there being a joint plan, common intention, and so on. Now, it is only when one gets to the further passage that follows that there may be a problem. But before going to that, directed in the terms in which the jury were up to page 130, line 14, I respectfully submit that they could only have convicted the appellant of murder if they found that he was party to a joint enterprise involving causing serious bodily harm or death. There would be no problem. The problem, if there is one, starts at page 130, line 14. But it's not the following lines that Mr. Knowles specifically complains about. Can I just ask you to look at those again with me? Now, you might ask, what is the common intention? Common intention means either that the defendant each intended, no problem up to that point, or the defendant whose case you are considering knew that there was a real possibility that the other defendant might have a particular intention and with that knowledge nevertheless went on to take part in it. Now, it's at that point that my learned friend complains, and complains also about the following passage. My lords, so far as that goes, with respect, our submission is that what the learned judge was here doing was directing the jury that there were effectively two routes to conviction. The first, common intention. The second, I entirely accept, but what has been referred to as parasitic accessory liability, but I may also refer to as category 3 liability, adopting the numbering given to the different types of joint enterprise in R and A. Now, where the judge says on page 130, or the defendant whose case you are considering knew that there was a real possibility that the other defendant might have a particular intention, and with that knowledge nevertheless went on to take part in it, my lords, I respectfully submit not only that that is a direction in accordance with Chang Wing Hsu, but also that read in context, the jury must have understood what the judge was obviously seeking to convey. And what the judge was obviously seeking to convey to the jury was that participation with such knowledge, knowledge of the real possibility of Hudson acting with a particular intention, which in context the jury could only have understood to mean the requisite intention for the crime or the offence with which he was charged, and otherwise murder, there was nothing wrong with the direction. My lords, it's worth bearing in mind that this case may very well have been a common intention case. I can't say it must have been a common intention case, and I do therefore accept that the alternative direction was necessary. But the reality is that what the judge did was direct them first in a way which cannot be complained about in terms of common intention and a joint plan. Secondly, in relation to parasitic accessory liability, he directed them in terms which I accept could have been fuller, but which must, in context, have made it plain to them that what mattered was that there was a real possibility that Hudson had the intention to commit the crime of murder, and that with that knowledge, the defendant, Ruddock, continued to take part in it.
Okay.
My Lords, all of that is set out in our printed case. There is very little more that can be said about it.
Understand.
It's either a sufficient direction or it's not. In my submission, it accords with the direction required by Chang Wing Sue.
This was a case, wasn't it, in which there was, on any view, a robbery and a murder.
Yes?
The defendant's case was that he wasn't there at all. Yes?
Yes. And it was a, yes, that's right, my Lord, yes.
Made by way of unsworn statement, but that was the
Indeed.
case the jury had to consider. Do you want to say anything about the particular difficulty that judges have to remind juries to think about when they reject wasn't there and need to go on to, supposing he was there, what then? In other words, is it enough to reject not there?
Well, my Lord, I'm not sure that the judge did direct the jury in those terms.
No, he didn't. But all right, it's the same point that was raised this morning. That the question is whether the jury's attention has been sufficiently directed to the possibility that he was a party to part of the offence and not the rest. Part of
My
the
Lord,
combined offence and not the rest.
Well, yes, my Lord, one point that arises from my own friend's submissions this morning relates to his knowledge or otherwise of the possession of the knife. Now, that wasn't a point that Mr. Knowles had made previously. Your Lordships are aware that according to the evidence of Corporal Grant, and my Lord, it is at page 37 of the bundle, the words used were, "Arna me tell you fee cut de man's throat." And Mr. Knowles suggested that the right way to read those words was, "I didn't tell you to cut the man's throat," and I respectfully agree with that. And that is the way that a Jamaican jury would have understood it.
Do we need expert evidence of that?
If it's agreed,
Well-
I think we do. Thank you.
My lady, the alternative formulation, "you think and me tell you fee cut de man's throat," which was not wording that he accepted was used by Ruddock, but was merely wording which he accepted he had put in his witness statement, makes no difference in my submission. In those circumstances, had there in truth been an issue as to whether he knew that Hudson had a knife, I would accept that there would have been a requirement on the part of the judge to direct the jury to consider that question. Now, the reality being in my submission that it was plainly open to the jury to infer from those words that he knew that Hudson had a knife. And if that weren't the case, surely the judge would have been asked to and would have directed the jury to consider the question.
Follow that point. Can we just go back to the summing up, page 131 for a moment?
Yes, my Lord.
Halfway down the page, there's a major paragraph, and the judge ends up saying, after referring to how the deceased was found, bound hands and feet and throat cut, you'll have to look at it, she says. He said, the judge then said, was this the work of one person or is it the work of two or more than two? So you apply your common sense to all of this.
Yes.
Was there a third possibility on the evidence? And if so, did the judge deal with it adequately? Namely, that it was part the work of the appellant, the tying up,
Yes.
but part the work of Hudson, the throat being cut.
Yes. Well, my Lord, on one level, yes, but what I was building up to submitting was that if the reality on the evidence was that the jury were bound to infer that he knew that Hudson had a knife, bearing in mind the state of the law as laid down in Chang and Powell, the jury would, in my respectful submission, have been bound to consider not only that he foresaw the possibility of the knife being used to cause grievous bodily harm or kill, but also bound to conclude in those circumstances that he was guilty of murder regardless of the precise parts played by each of them.
Yes. What's the alternative disposal if, contrary to your submissions which you're about to make on the main point, the board was satisfied that the Chan Wang Su approach isn't sound? How would that then affect this conviction?
How would it affect the position, my lord? Or
Affect this conviction?
Yes, I see, my lord.
Which is looking at it on a different hypothesis, given the fact that there were two offences involved and the way in which the judge has approached it.
It would depend. On one view, it would be a case of manslaughter.
Yeah.
And that would be my primary submission.
Yeah.
On another view, having, in the circumstances you put to me, quashed the conviction for murder, the question would become, should there be a retrial?
Yeah. So, in other words, if Mr. No succeeds on his argument on the general point, you wouldn't argue that the murder conviction could nevertheless stand.
If he succeeds on the general point, my
Yes.
lord, does my lord mean that the general point under this ground?
No, the Chan Wang Su point.
Oh, forgive me. Well, that would rather depend on what your lordships were to say, because a number of options have been suggested, and with respect, one would have to know exactly what was in your lordship's mind.
Does this
in
mean,
order
I was going to raise this,
Definitely.
does it mean that the actual outcome of the appeals may, particularly if we do accede to the appeals on the general point, as it's been called, the actual outcome of the particular appeals may have to wait for further submissions depending on what we say?
Well,
If
there might be a number of stages,
if we uphold the general point, if we
yes.
uphold your position and Mr. McGuinness's position on the general point, then this appeal simply comes down to the two specific points,
Well,
and that we can deal with that. But if we allow the appeal on the general
point, yes. Well, my lord, if you allow the appeal on the general point on the basis that Chan Wang Su should be departed from,
Yeah.
therefore a different direction, whatever that may be,
Yeah.
ought to have been given, then I think it would follow that the jury had been misdirected. You would have to quash the conviction of murder, but there might be an interregnum before it would be possible to consider whether it would be appropriate to substitute manslaughter or it would be necessary to remit the case to the Court of Appeal to consider whether there should be a retrial. Because,
Okay.
But those would be the...
And what's your
my lord, yes.
So what's your just looking ahead? If we were to allow the appeal on the general point in principle, it would follow that the convictions for murder would be quashed.
Yes.
And the question then you would like time to consider and presumably make written submissions on would be what then follows.
Yes.
Is that
What my
right?
lords could do,
I don't know.
what my lords could do
yeah.
procedurally is simply allow the appeal without quashing the conviction,
Okay.
so that
Yeah.
an alternative could be
I
substituted.
don't want to spend too much time on this. Maybe you and Mr. Knowles could discuss this over the adjournment this evening and either tell us what your agreed position is, or if you haven't got an agreed position, explain what the differences are. And similarly, in the Jogee appeal,
Yes,
if
my
there are
lord.
any
I mean,
implications for that.
If I can just make my position clear, as things stand, I would accept that the conviction couldn't stand,
Most of you made that point.
and I've made that point. What I'm less sure about, would like to consider, is whether it be appropriate to
understand.
quash because of the implications that flow from that.
That I understand. Well, if you could respectfully discuss it and hopefully reach an agreed position on each appeal, but if not, we'll identify the issues.
Could I just go back to the much more mundane and particular point that you made about about the jury in this case?
Yes, my lord.
What is the reason why the jury was pretty well bound, as you would say, to infer from what Ruddock said to the policeman that he knew that Hersey had a knife before the throat was cut?
Hudson.
Hudson, I beg your pardon, Hudson. But the
My
point is,
lord,
before
what
the threat was made.
what he's saying is, I didn't tell you to use the knife.
I see.
Now, it
Yes,
wouldn't
I
make sense
follow
to
that.
say that with respect if he hadn't known about the knife beforehand, because what he would have said surely would be, I didn't know you had a knife, and I certainly wouldn't have agreed to you using it.
Well, I wonder. Anyway, that's the reason why.
That certainly is the way I would answer the question.
Okay.
So, my lord, we come to the second of the two grounds, which is
Hearsay evidence, you know.
yes, the hearsay evidence. Now, my lords, you haven't actually been taken to the transcript in this respect. Could I just detain you for a moment with it? Page 67 is the starting point. Now, just before Detective Spence gave the evidence to which objection is taken, the judge told prosecuting counsel to be careful.
Yes.
Now, Your Lordships, perhaps we could start at line 10. I told him, so that's Corporal Spence, I told him that the female was located. Yes, you said the female was located. What else you said to him? I told him that she can identify the photograph. At that point, the judge said, Miss Jackson, but then there was a further question. After you told him that, what next? What happened after you told him about locating the female? And at that point, the judge interjected and said, I'm saying be careful in asking the question because we don't want hearsay to come in. You can do certain things, but you have to be careful as you lead the evidence.
Yep.
You spoke to him in relation to the photograph, and what? The lady? And then the judge himself asks what you said to him. And at that point, the question is picked up by counsel, what you said to him. Answer, I told him the female had explained to me that, told me all what they have done to her and the deceased. And my lords, I just pause there to note that what was said was done to her and the deceased, not just to her. Pete Robinson, while they were on the beach at White House in St. James. Now, when you said this to him, did you do anything in relation to Mr. Ruddock now? I collected a statement from him. After you said this to him, so that must be the words that he relayed to him that she had uttered, what was the next thing happened after that? Did he respond? Yes, ma'am. And then, instead of being asked what he said, we get a leading question, and what you subsequently did? You make an arrest in this matter? Yes, ma'am. And who did you arrest? I arrested Hudson and Ruddock. Cautioned them? Cautioned Mr. Ruddock, said that he tied up the foot and the hand of the deceased, and Hudson used a ratchet knife to cut his throat. Yes. So, my lords, just summarising that, it's unclear exactly what it was that the judge may have been specifically concerned about, and it's curious because the judge himself asked the question, what you said to him, and it was that prompted counsel to ask the same question, which then led to the answer which is now complained about. Be that as it may, Corporal Spence was asked whether the appellant responded, to which he said yes, but he wasn't asked what the response was. Instead, we got a leading question, and in answer to that question, he went on to say that he arrested the appellant and Hudson, and then, very shortly after that after being cautioned, the appellant stated, in other words, he made the confession. Now, it's quite possible, my lords, although I entirely accept that the judge didn't read it this way, that answer was in fact the appellant's response after caution, which we don't get because the question wasn't asked because the leading question was asked. So we don't know what he said. We know he said something after caution. We don't know what it was. But shortly afterwards, cautioned Mr. Ruddock, said that he tied up the foot. Anyway, the position is that very soon after he was cautioned, he made this admission. Now, my lords, I ought just to take you to page 145, where the learned judge directed the jury in relation to this. And
Thank you.
starts at line 21. Now, remember, counsel for the defence addressed you on that. He said, him don't hear from this lady. We don't know what he said. Well, that is true. We didn't hear a word from her. We don't know what she said, and we cannot speculate. Do not allow your jury minds to wander, to say, wonder what she might have said. We don't know. It's like she never existed, Mr. Foreman and members of the jury. You look at the evidence and deal with the evidence alone. Now, having spoken to this lady, however, Corporal Spence went back to Ruddock and said he located the lady, and the lady told him what they did to her. Now, it's there that there's a mistake, because it wasn't just her, at White House on the beach, and what they did to Mr. Robinson. In fact, it's there, but it's not together. Well, so you will have to, I mean, the evidence was,
Yeah, they did there, Mr. Robinson. But anyway.
So you will have to look at that, Mr. Foreman and members of the jury. This is what was said of Ruddock. What was his reply? There seems to have been no reply. Now, 2 points. First of all, there seems to have been no reply is certainly the way the judge read it, and I accept that that is the way the jury were directed. It seems to me entirely possible, given that what he said was undoubtedly shortly after he was cautioned, and he wasn't asked what he said upon caution, that the words, in fact, were uttered in response to the caution. But that we don't know. The second point, the more important point, the judge here says you will have to look at that. And the complaint is, effectively, that he was directing the jury to consider what the lady said. Well, in my respectful submission, the judge's focus at this point was not on that. It was on the appellant's reply. It was that he was telling the jury to look at. It was that mattered. And he had previously directed them, as I've just read in the clearest terms, that they didn't hear from her. In other words, she didn't give evidence. They shouldn't speculate. It's as if she never existed. Right. Now, my lords, it's in those circumstances that we submit that what was said by her and relayed by Spence was admissible, but not as evidence of the truth of its content, rather merely as evidence of what Spence told the appellant in order to provide the context for the admission. And if that's right, and this is the first of my 2 submissions on this ground, there's nothing objectionable about the evidence. And again, I reiterate, the judge did tell them in terms, not to speculate about what she would have said. The second point, my lords, is this, though. I don't accept, with respect, that the hearsay, as it's categorised, was objectionable. It did not include any detail regarding what may have been done to the woman, as distinct from the deceased. The information simply alluded to what was done to both her and the deceased. And it did not, on any view, lead to the inference that effectively you are invited to draw, namely that she was raped or sexually assaulted, or at any rate that the jury would have drawn that inference. It is quite right, as Mr. Knowles has said, that in fact there was a separate indictment for rape, which, as I understand it, was not proceeded with, but that was certainly nothing that the jury knew anything about. So, my lords, in those circumstances, in short, my response is it wasn't objectionable because it provided context. It wasn't relied upon for the truth of what she said. If I'm wrong about that, it wasn't prejudicial. It related to both of them. It was in general terms, and it did not, on any view, lead to the inference that she was sexually assaulted.
What about, I told him that she can identify the photograph?
Well, my lords, that was simply evidence that he recognised her photograph.
No. It's evidence that she, isn't it?
Well, it was a photograph of her.
It's a photograph of her. Sorry, yes, you're quite right. Okay.
So he recognised her as being
that's
the
a sufficient
photograph.
answer. Thank you.
So I don't think anything flows from that. I mean, we obviously don't know, and
No, they're quite right.
Mr. Knowles sought to suggest that the photograph might have been interesting, but we simply don't know, and it's of no relevance.
No, we don't.
So, my lords, unless I can assist you further in relation to the 2 grounds of appeal against conviction on the assumption that the law is as it's currently understood, I will move on to the main issue, if I may.
Thank you very much.
Can I say, because you've been shown a lot of the authorities, both by Ms Geary, Mr Knowles, and also now by Mr McGuinness, that I don't propose to take you to the key authorities.
I'm very grateful.
May I, though, associate myself with what Mr McGuinness has said about variously the early origins, and I accept, of course, that one doesn't get very much from those early command cases and procurement cases. All I would say is that on a general level, a test based on foresight of consequences is not something completely new, because it did in those cases feature. It was articulated by Hale, similarly later by Foster in the context of the command cases. It's also apparent from some of the very early common purpose cases. The rationale being, as Foster put it in relation to the command type case, that although the event, using the language we've been using in this appeal, crime B, but not strictly crime B in a procurement case, obviously, may have been out with D2's original intention, it was, in the ordinary course of things, the probable consequence of what D1 did under the influence and at the instigation of D2. My lords, it's dealt with in our foundation's note. All the relevant passages from Foster, Hale, and others are set out, and I won't dwell on it any further, but I do associate myself with what Mr McGuinness has said about the early origins to that extent, and I don't suggest that they provide an answer or that one can trace seamlessly through from those cases to Chan Wing Hsu, the articulation of a principle based on foresight. Secondly, I associate myself, if I may, with his submissions in relation to manslaughter, and thirdly, variously Smith, Wesley, Anderson, Johns, and Hui Chi Min in particular. So, my lords, having done that, and not bothering you further with those authorities, can I just deal on a more general level with the notion of contemplation or foresight as a test? And for the purpose of the submissions that we make, I've already mentioned that we may use, and we have used in our written materials, the term Category 3 liability, that being shorthand for the third type of joint enterprise liability identified in R and A at paragraph 9. And by that we mean parasitic accessory liability. So if I use both, I hope I'll be forgiven. I'm talking about the same thing. Now, my lords, when analysed in the abstract, the distinction between common purpose joint enterprise of the classic type and a Category 3 or parasitic accessory liability joint enterprise can appear greater than it often is in my submission. In a common purpose case, D2 is taken to intend the criminal acts performed in furtherance of the common purpose. And take that from paragraph 20 of Mr. Knowles' foundation note, to which he referred you when he addressed you. Now, in a joint venture case, those acts may not, however, all be specifically agreed. In a paradigm case, the nature and precise scope of the enterprise may be agreed, and there may therefore be shared or common intent in respect of the shared objective. But that's the paradigm case. In all other cases, and there will be many, and these appeals are but two examples of them, the enterprise, if it is an enterprise, will not be so closely defined. And the question therefore arises, what test should be applied to decide what further offences ought nonetheless to be considered as falling within the common enterprise, even if not specifically agreed or intended. Now, the foresight test we submit provides a coherent answer to the question in a Category 3 or parasitic accessory liability joint enterprise type case. Now, my lords, for what I'm purpose of what I'm going on to say, I'm prepared to suppose that contemplation or foresight has been elevated, as it's been suggested it has by both Miss Geary and Mr. Knowles, from what may have been an evidential test only, so that it has become part of a legal test. Yeah. Now, I say part because what Sir Robin Cook in Chang Wing Siu, and you were referred to it by Mr. McGuinness, and indeed Lord Steyn in Powell, and others have made absolutely clear is that the criminal culpability, and that's very important because we've been talking about mens rea, the criminal culpability in such a case lies in participating in the venture with foresight. So this isn't guilt by foresight alone, and it's not in my submission the lowest possible form of mens rea looked at in that way. Now, the question, and I respectfully submit arguably the most important question before your lordships, is there any reason in principle why the common law should not have developed in that way? And the answer that we suggest is no. Put another way, is there any reason why the jury should not be directed in that way? Again, no. Now take common purpose liability. It depends on agreement, but that may be, and often will be, tacit agreement, even in a classic case. In such a common purpose case, none of the participants will necessarily communicate his or her agreement. Rather, the Crown will be asking the jury to invite or to infer that there was agreement. And that has effectively been the position since the early poaching cases, because in those cases, although, as Mr. Knowles himself pointed out, we have to be a little bit careful about how the language of intention and foresight was used in those early cases. In those cases, effectively, intention was presumed in the circumstances. So very similar to what I'm talking about, where in a common purpose case, there may be no communication of agreement. Rather, the Crown's case will be that it was understood, and the jury will be invited to infer agreement. Now, what then is the position in a Category 3 type case, a parasitic accessorial liability case, when properly analysed? Well, there will be agreement to commit crime A. In the old cases, poaching, or in the modern context, perhaps burglary or robbery. D2, however, foresees that D1 may commit a further crime, crime B. D1, for his part, will intend to commit crime B, he being the principal, either at the outset or at some later point, and possibly, I accept, only shortly before he commits it. But the point is this, that having foreseen crime B, D2 continues to participate, as I've already submitted. And therefore, at the point when crime B is committed, there is, we submit, and I'll be taking your lordship just to Sir Robin Cook in this respect, based on such continuation with foresight, tacit agreement or authorisation.
But when you use the phrase continues to participate in the venture, that rather begs the question of what he is participating in. It's aligning participating in what you've termed A with participating in B, and it's defining the venture as including B. If your posture, therefore, in a sense, answers his own question.
Well, my lord, in any real sense, crime A, or the original venture, has, once two things have happened, first, D2 has foreseen a further crime, and secondly, he has continued to participate in it.
Right, well,
the venture has
continued to participate in it
Or
What is
continue
it?
to participate, my lord. There's no magic in the words "in it," but "in it" could mean in crime A from his perspective, realising nevertheless that the other defendant may commit another crime.
Yeah.
Now, on any sensible view, the overall venture has expanded in those circumstances. That's how I answer the question, my lord.
Right.
It's not the original venture, I entirely accept. It is an expanded venture.
Yeah, so the proposition is the venture is determined, the scope of the venture depends on what anybody can foresee might be done. What anybody can foresee might be done defines the venture.
Well, no, my lord, not just foresees. Foresees and makes the decision to continue to participate.
Yeah, but
therefore,
sure, but the participate in poses the question, participate in what? And you say, well, the venture, what it is defined by what he foresees. I think that's your argument.
well, my lord, I'm not sure with the greatest respect I would accept that it's defined solely by that, because he continues to participate, and there comes a point when the other participant acts for the purposes of carrying out crime B.
But how do you
And it is
determine the scope of the venture in which he's participating? You say the yardstick definitive is his foresight. His foresight is not merely evidential, it is definitive.
Well, my lord,
Purpose of law. That I think is your argument.
well,
If not, what is your proposition as to how the scope of the venture is determined?
my lord, the reality is that there is something happening, crime A. It is then foreseen by the second defendant that the principal may commit another crime. The second defendant continues to participate in crime A, let's leave it at that, but contemplating that the second crime will be committed.
Or maybe.
Or may be committed, yes, may be committed, and that's certainly all that's required. Now, once it is committed, on any view he is party to something that he has contemplated, which has expanded from crime A to include crime B. And it's all part of a continuum of action.
So the answer to my question, how do you determine the scope of the venture, it's by a combination of what he foresaw might happen and what has in fact happened.
Well, yes, I suppose that is right, my lord, yes. So, my lord, the entirety of the venture may not crystallise until that latter point. But it's nonetheless a process in which he is engaged. There is this caveat, my lord, that it may well be that in fact, and I ought to qualify it in this way in retrospect, it may well be that D1, the principal, will commit a series of acts which are beyond the scope of crime A, but preparatory to the commission or completion of crime B.
But if they're foreseen as possible, then the scope of the venture becomes enlarged when he does them.
It may
your
become
proposition.
enlarged before you get to the point of him in fact committing the crime, but when he commits or does acts which are part of that process.
Yeah.
And there'll be infinite variables on the facts.
Thank you.
Does that analysis cater for the Mustill case?
Well, my lord, I was going to come
to
to
it when
the
you're ready.
Mustill case, if I may. So, my lords, the point we've reached, I think, is that having foreseen crime B, the second defendant continues to participate, and at the point when crime B is committed, there is, we submit, based on such continuation with foresight, tacit agreement or authorization. by that point, it has been authorised what is done. Now, my lords, that won't be the subject of express communication or agreement any more than you have express communication or agreement in many paradigm common purpose cases. But it is a matter of tacit agreement, as I've submitted.
And that's a proposition of law, not one of fact. In other words, the jury would be directed not that you may, members of the jury, infer, you may think it's very strong evidence that he was willing to continue, but rather it is a ruling as a matter of law that by continuing, he is guilty.
Well, my lord, that would certainly be my primary suggestion.
Yes, sure.
If I'm wrong about that, then obviously it would be an evidential question for the jury.
Yeah.
Now, it won't at that moment at which tacit agreement is reached by continued participation necessarily be a common paradigm, common purpose case, because the second defendant may very well not want the first defendant to commit crime B, and it's here, my lords, that I come to Lord Mustill.
Yeah.
Because D2 not wanting D1 to commit crime B is the first of the two problem scenarios envisaged by Lord Mustill in Powell. But even in that situation envisaged by Lord Mustill, if D2 continues to participate, he can nevertheless be said to have tacitly agreed and or to have authorised crime B in my submission, again on the basis of his continued participation. My lord.
But Lord Mustill comes to the view that that just isn't sensible.
Well, my lord, with respect, I would disagree for this reason, that there is nothing conceptually problematic about it.
Nothing odd about reluctant agreement.
Well, the fact that he may not want the outcome has nothing to do with it. It amounts, nevertheless, to agreement or authorisation, albeit, if I can put it this way, reluctant agreement.
And you infer that from the fact that he's gone on with the venture.
My lord, yes. Yes. We all do things we don't want to do. We do things reluctantly. Now, my lord, we submit that there's nothing conceptually wrong and therefore no problem with the first of Lord Mustill's scenarios. And my lord, the reference is volume 2 at 730, which is, I think, page 3516 in the additional bundle. That's where Lord Mustill expresses the two concerns he has, which led him to question how it was that tacit agreement could be the underlying rationale. Now, if I'm right, and that by continuing to participate you are authorising, and that is the equivalent of tacit agreement, and I'm also right that you can do that even if you are not wanting to do that, you can do it reluctantly, there is no problem with the first of the two scenarios.
So you say it's still subjective,
Yes.
in the sense that you are subjectively agreeing, subjectively going along with it. It's more you're objectively, because you foresee it and you are, as a possibility, you're going along with it.
Well,
But
say that there's no doubt that the test is a subjective one.
quite.
My lord, I may be missing.
No, it just seems to me that that if it is subjective, then you don't, you're not. Then I don't think you get round Lord Mustill, except by saying it suddenly becomes objective, because you're going along with it.
Well, no, my lord. You can subjectively not want to participate or continue to participate, but for any number of reasons, perhaps because D1 is overbearing, continue to do so. And that may be a conscious decision. I don't want to do this, but I'm going to. There are plenty of examples, no doubt, that we can all think of, when situations like that arise day to day. Now, my lord, I'm sorry, my lord, would you forgive me?
That's foreseeability rather than agreement.
Reluctant agreement is opposite.
Yes.
Now, my lords,
suppose that's right.
I suppose a way of looking at it, and perhaps fusing the objective and subjective. My Lord's obviously concerned about the objective
No,
element.
I do see how reluctant agreement is a possibility, the way you put it, yeah.
My Lord, another way, though, of looking at it in terms of analysing it might be to say, well, it certainly has to be subjective foresight,
Right.
but you might test the question of whether there's agreement objectively by simply asking the question, did he continue? But it doesn't make a difference.
This is slightly my point, that really it comes back to foresight plus continuing to participate. Doesn't, but I see how you can put it into reluctant agreement by continuing to participate.
Well,
as you say, it doesn't really matter.
Well, my Lord, it doesn't. And in my respectful submission, although with some trepidation, I respectfully submit that's a complete answer to the first of Lord Mustill's concerns, if this is properly analysed in terms of acceptance amounting to authorisation. Now, just interposing for a moment, arguably, on one view of the evidence, that could have been the position in the present case. I didn't tell you to cut his throat. You know, arguably. But, my lords, can I come now to Chan Wing Siu, which you have at volume 1, page 13, I think it is, but at any rate, if you could turn up, please, page 18. It's tab 2, page B18. Now, my lords, letter G, I hope you'll forgive me just for reading it one more time. It's all I'm going to read to you in terms of the authorities. The case must depend rather on the wider principle whereby a secondary party is criminally liable for acts by the primary offender of a type which the former foresees but does not necessarily intend. Now, the next passage has been the subject of some criticism on the basis that it is said contemplation and authorization are there conflated. Now, my lords, before I deal with that, it is, in my respectful submission, tacit agreement or authorization by virtue of continued participation that Sir Robin Cook is talking about, and that's absolutely plain in my submission from the last sentence at letter H. Now, I respectfully submit that it is inconceivable, despite the literal reading of the sentence beginning, it turns on contemplation, and I obviously accept the literal reading, it is inconceivable that Sir Robin was in truth conflating contemplation and authorization. Now, looking across the page, at the top we see set out Geoffrey Lane's submission. And it's absolutely clear from the reliance placed by Sir Robin on that passage from Anderson, which equates tacit agreement and authorization, because we see it, looking at the top of page 176, B19, about 5 lines down. If one of the adventurers goes beyond what has been tacitly agreed as part of the common enterprise, his co-adventurer is not liable for the consequences of that unauthorized act. Finally, it is for the jury in every case to decide whether what was done was part of the joint enterprise or went beyond it and was in fact an act unauthorized by that joint enterprise. So it's absolutely clear from the reliance placed by Sir Robin Cook on that passage in my submission, which equates, as I've said, tacit agreement and authorization, that by authorization, in the passage at the bottom of page 18, what Sir Robin Cook meant was tacit agreement, which, as he put it, must maybe express or implied. And that is reflected in the important sentence at letter H: the criminal culpability lies in participating in the venture with that foresight. Now, the foresight is obviously the contemplation in the previous sentence. And it's the participation, I submit, which he's talking about at letter H, which signifies the authorization.
Yes, I see.
But put another way, despite the plain wording of the sentence and the suggestion that there is conflation, If I'm right that authorisation, bearing in mind the reliance placed on the passage from Anderson, means tacit agreement, and that therefore Sir Robin Cook had agreement in mind, it is simply very difficult to understand how he could have conflated, on the one hand, contemplation, and on the other, agreement. And therefore the sense I make of this is, I suppose, by inserting, after it turns on contemplation by continued participation, or putting the same idea, in other words, authorisation. Now, I accept, my lords, that that's not exactly what the words say, and I accept, moreover, that they say something which it makes it very easy to suggest that there's a conflation. But the sense of what he was saying was that it's the continued participation that signifies the authorisation.
Yes, I think.
Now, my lords, the further problem scenario identified by Lord Mustill in Powell presents greater difficulty, I accept. And that was where there is evidence that D2 made it plain that he did not want D1 to commit crime B. Likely to be quite a rare case in my submission, but nevertheless a possibility. Now, in that rare case, we would accept that there would be a need for a direction to the effect that the jury must consider whether D2 nevertheless, in all the circumstances, agreed to or authorised crime B, and it would have to be drawn to the jury's attention that it had been communicated by D2 that he didn't want this offence to be committed. And the jury's answer might be in the negative. But even that scenario can be accommodated in the sense that the jury might find that despite, in that rare case, communicating that you didn't want the crime to go ahead, you could nevertheless agree to it and thereby aukhorise it.
So again, your answer's the same, really, reluctant agreement.
Yes, we are, but it's at a remove which makes it slightly harder.
Makes it easy,
Makes
makes it more difficult.
it more difficult,
Well,
and as I hope I fairly conceded, might require a further direction to the jury so that they're specifically alerted to that and asked to consider it in those circumstances.
Understand. Thank you.
But, my lords, that exposition, really working from first principles and no more, but also looking at Chan Wing Siu, is, in my respectful submission, a way of making sense of the authority and its adoption in Powell, and explains away, if I'm right, the various problems that have been put forward conceptually, and in particular, Lord Mustill's two concerns. Now, my lords, can I move to mens rea and make what is obviously a very obvious point first, but an important point. There's no requirement in either basic accessory liability or parasitic accessory liability that D2 and D1 must share the same mens rea. But parasitic accessory liability does not depend only on foresight, as is effectively suggested. In a parasitic accessory liability case, D2 is already engaged in a criminal enterprise because it doesn't bite unless crime A is, well, it is a crime. His culpability in relation to crime B lies indeed in the fact that he continues to participate in crime A with foresight that D1 may commit a further offence. So, my lords, looking at the two types of accessory liability, in a case of aiding and abetting, D2 must have the requisite mens rea to aid and abet. In a Category 3 or parasitic accessory liability case, D2 must have the requisite mens rea to commit crime A.
Can you give us an example of basic accessory liability, the accessory before the fact, or the principal, the secondary degree, who does not share the mens rea for the offence with the
My
principal?
Lords, in due course I'll take you to a case called Bryce, but my understanding, at least, of basic accessory liability is that you have to intend two things. You have to intend the act which you do, which is said to amount to the assistance. You have also to intend to assist,
Yeah.
but you do not have to intend the outcome.
I think that you have the majority of the divisional court in NCB and Gamble on your side
Yes,
on
you
that.
would.
Yes. My Lord, I'm not sure that's an answer to your Lordship's question, but I hope it is.
Well, it's certainly an answer, a partial answer to it, that your accessory may not always wish the offence to be committed if he nevertheless helps it to be committed. And NCB and Gamble may well be an example of that.
But he may intend to help, but he may not intend
And the
that
offence
the crime
to be committed?
is committed. And there is a real distinction there, my Lord.
All right, thank you.
And it's in those circumstances that there is an identity between, on the one hand, basic accessory liability and parasitic accessory liability, because in neither case is there identity of mens rea between the principal and the secondary party. But, my Lords, goes further than that, the similarity, because I respectfully submit that in each case, well, my Lords, in each case there is a criminal enterprise. That is the second similarity. And thirdly, in each case, D2 may be liable, I submit, and I'll seek to make this good in a moment, on the basis of foresight of crimes not intended or wanted by him. And, my Lords, I'll take you, if I may, briefly to just a little bit of law in relation to basic accessory liability, starting, in fact, with, although I won't refer you to the case, Johnson and Uden, and then touching on the case of Bainbridge and a couple of other cases. But, my Lords, before I do that, can I just say one more thing about mens rea? Those representing Mr. Jogee have suggested that there is a vanishingly small, those are the words used, difference between Category 3 or parasitic accessory liability and constructive malice, as it was felony murder in some of the Caribbean countries, which of course has been abolished, both here and in Jamaica, although recently reintroduced in Trinidad and Tobago. Now, the answer to that, with respect, is this, that Category 3 liability based on foresight is not in any sense a replacement for the felony murder rule, since it requires foresight of crime B before D2 can be found guilty of it. He's not guilty of crime B merely because he was engaged in crime A. Moreover, it depends upon D2 participating in crime A, it's the same point, with that foresight. Now, my Lords, it's those things in combination which make D2 liable in the circumstances with which we're concerned, which is far removed from the felony murder rule or constructive malice rule. And as Lord Steyn observed in Powell and English, and if I could just give you the reference,
Yep.
because he said something very similar to what I've just said. It's Volume 2, Tab 23, page 733. As he said there, and I won't invite you to turn it up, D2's liability is predicated on his culpability in respect of the greater offence. So in other words, he was adopting exactly what Sir Robin Cook was saying about the culpability for the greater offence lying in foreseeing it and participating. Now, my Lords, could I then turn briefly to basic accessory liability and foresight? And my general submission is that depending on the facts of the case, basic accessory liability also employs a test of foresight. I'm not suggesting there doesn't have to be intent to do the act which is said to constitute the assistance or intent to assist. I'm talking about foresight at the last stage. Now, the suggested reformulation of the certified questions in Jogee and the direction for which Ms. Geary contends, paragraphs 16 and 164 of her case, suggests that the jury should be directed to consider whether D2, I quote, knew D1 would, end of quote, ... end of quote. A formulation which is said to derive from Johnson and Uden, which you have at volume 1, tab 9, page 1950, where, of course, it is said that what is required is knowledge of the essential matters. But in my respectful submission, knew D1 would has never been the law of basic accessory liability, which is hardly surprising for reasons that were touched on early yesterday, I think. It is impossible to know that a future event will happen. At its highest in basic accessory liability, the requirement has been articulated, I submit, as knowledge that a particular result is intended at its highest. But, my lords, it was not long after Johnson and Uden before the requirement was looked at in the case of Bainbridge, to which you were referred by Mr. Knowles, but is at tab 16, page 592.
592.
Yes, my lord. And perhaps, my lord, I could just ask you to turn that up.
Yeah.
Two paragraphs from the bottom. The court fully appreciates that it's not enough that it should be shown that a man knows that some illegal venture is intended. So there's the formulation of something being intended, or knowledge of something being intended. To take this case, it would not be enough if he knew, he says he only, I'm sorry, my lord.
Yeah.
To take this case, it would not be enough if he knew, he says he only suspected, that the equipment was going to be used to dispose of stolen property. That would not be enough. Equally, this court is quite satisfied that it is unnecessary that knowledge of the particular crime, which was in fact committed, should be shown to his knowledge to have been intended. So there's not even a requirement that the particular crime needs to be shown to his knowledge to have been intended. And by particular crime, I am using the words in the same way in which Mr. Simpson used them, namely on a particular date and particular premises. Now, just reading the next bit, it is not altogether easy to lay down a precise form of words which will cover every case that can be contemplated, but having considered the cases and the law, this court's quite clear the direction the judge, which was challenged, cannot be criticised. Now, just pausing there, I will need to turn the page. The ratio of this case is, it seems, with respect to me, to be quite clear, it's not enough to know that some illegal venture is intended. In other words, without knowing the type of venture. But equally, knowledge that the particular crime committed was intended is not necessary. Now, my lord, I said I'd have to turn the page, and I do so because the passage which Mr. Knowles, I think, prayed in aid is at the middle, where it says, Judge Arvold, in this case, in the passage to which I have referred, makes it clear that there must be not merely suspicion, but knowledge that a crime of the type in question was intended, and that the equipment was bought with that in view. Now, my lords, that was in 1959.
Yes.
Then in 1978, in Maxwell and the DPP of Northern Ireland, which is at volume 3, tab 42, page 1183, in Maxwell, Sir Robert Lowry, as he then was, decision that knowledge that one of a range of offences is intended is enough. was endorsed by the House of Lords. My Lords, if you could just go to page 1190.
Yep.
Letter B, the only substantial matter to be discussed in the appeal is the degree of knowledge required before an accused can be found guilty of aiding, abetting, counselling or procuring. To what extent must the accused be proved to have particular knowledge of the crime in contemplation at the time of his participation and which was ultimately committed by the principal perpetrators? For myself, I'm content for this purpose to adopt the words of Lord Parker in Bainbridge, when, after saying that it's not easy to lay down a precise form of words which will cover every case, he observed at page 134 that there must not be merely suspicion, but knowledge that a crime of the type in question was intended. In the words of Lord Goddard in Johnson and Uden, endorsed by this House, before a person can be convicted of aiding and abetting the commission of an offence, he must at least know the essential matters. The only question in debate in the present appeal is whether the degree of knowledge possessed by the appellant was of the essential matters which constitute the offence in fact committed, or to put what in the context of the instant case is exactly the same question in another form, whether the appellant knew that the offence in which he participated was a crime of the type described in the charge. My Lords, if one then turns to page 1195, just after letter E, I think Bainbridge was correctly decided. This is Lord Scarman's speech, forgive me. I have moved from one to another. The previous was Lord Helsham, which I should have identified. Lord Scarman, after letter E, I think Bainbridge was correctly decided, but I agree with counsel for the appellant that in the instant case, the Court of Criminal Appeal for Northern Ireland has gone further than the Court of Criminal Appeal for England and Wales found it necessary to go in Bainbridge. It's not possible in the present case to declare that it is proved beyond reasonable doubt that the appellant knew a bomb attack upon the inn was intended by those whom he was assisting. It is not established, therefore, that he knew the particular type of crime intended. The court, however, refused to limit criminal responsibility by reference to knowledge by the accused of the type or class of crime intended by those whom he assisted. Instead, the court has formulated a principle which avoids the uncertainties and ambiguities of classification. The guilt of an accessory springs, according to the court's formulation, from the fact that he contemplates the commission of one or more of a number of crimes by the principal, and he intentionally lends his assistance in order that such a crime will be committed, according to Sir Robert Lowry. The relevant crime, the Lord Chief Justice continues, must be within the contemplation of the accomplice, and only exceptionally would evidence be found to support the allegation that the accomplice had given principal a completely blank cheque. The principle thus formulated has great merit. It directs attention to the state of mind of the accused, not to what he ought to have in contemplation, but what he did have, avoids definition and classification while ensuring that a man will not be convicted of aiding and abetting any offence his principal may commit, but only one within his contemplation. He may have in contemplation only one offence or several, and the several which he contemplates he may see as alternatives. An accessory who leaves it to his principal to choose is liable, provided always the choice is made from the range of offences which the accessory contemplates the choice will be made. Although the court's formulation of the principle goes further than the earlier cases, it is a sound development of law and in no way inconsistent with them. Now, my Lords, I don't think I need read any more of that. More recently, the knowledge requirement in basic accessory liability has been reformulated in a number of more modern cases in terms altogether more general, but of contemplation, entirely consistently with Category 3 liability. Now, there's a shorthand way of dealing with this. Could I just ask you to take Volume 1 and look at the Law Commission's 2007 report, which is at tab 13, and specifically at page 3. Forgive me, my Lords, I just need to find the... Yes, page 377, my Lords. Paragraph 2.64. what is meant by knowing the essential matters? No joint criminal venture. So this is considering the position where there is not a joint criminal venture. If D has to know the essential matters of the principal offence, it might be thought that D must know or believe that P is committing or will commit the conduct element. Well, just pausing there, that is effectively what Ms. Geary contends for, and which already, by the date of Maxwell, can be seen not to be the level of requirement in accordance with Johnson and Newton, because there's already a test of contemplation which has expanded from Bainbridge to Maxwell. Turning the page, P is doing or will do in the circumstances and with the consequences unless the offence is constructive offence, proof of which, etc. Now, paragraph 2.65. However, the courts have demonstrated a readiness to dilute the stringent fault requirement of knowledge. With regard to the conduct element of the principal offence, there are authorities that can be cited in support of no less than 4 different tests, each of which requires something less than a belief that P will commit the conduct element. The tests are: 1, belief that P might commit the conduct element; 2, foresight of the risk of a strong possibility that P will commit it; 3, contemplation of the risk of a real possibility that P will commit it; and 4, foresight that it is likely that P will commit it. And there are footnotes to each of those, and one finds references to cases at the bottom. My Lords, and it may be that we should have provided, and if your Lordships would like them, we will, all of these cases. You have one of them in your bundle, which is the case of Bryce, I think it is.
It is.
I'm very grateful, my lady.
133.
I'm grateful. 1483, which is volume 4 for those of you using the hard copies, and it's tab 54. Well, it may, because it may also assist in answering question my Lord Hughes put to me earlier about intention, be helpful just to look at several passages, and I hope you'll bear with me. I don't foresee any difficulty in completing within my time tomorrow. Thank you. So paragraph 42, well, also, I think in the circumstances I don't need to invite your attention to the facts, but if that becomes necessary, I will. Paragraph 42, as to A, it's necessary to show, firstly, that the act which constitutes the aiding, abetting, etc. was done intentionally, in the sense of deliberately and not accidentally.
Sorry, I'm behind you. Page.
I'm sorry, my Lord.
Paragraph.
My fault, my Lord. 1493.
Thank you very much.
Paragraph 42 at the top.
Thank you.
As to A, it's necessary to show, firstly, that the act which constitutes the aiding, abetting, etc. was done intentionally, in the sense of deliberately, and not accidentally, and secondly, that the accused knew it to be an act capable of assisting or encouraging. And 43, as to B, it's now well established that it is not necessary to prove that the secondary party, at the time of the act of aiding, abetting, etc., intended the crime to be committed. My Lord, that's the point that I was making earlier. And then, my Lords, just dropping down the page to paragraph 46, it not being necessary to show that the secondary party intended the crime to be committed by the perpetrator, what must be his state of mind vis-à-vis the commission of the crime? As was stated by Lord Goddard in Johnson, before a person can be convicted of aiding and abetting the commission of an offence, he must at least know the essential matters which constitute the offence. And, my Lords, at 47, reference to Maxwell, and the passage which I've already read and won't therefore read again, springs from the fact he contemplates the commission. Then at paragraph 48, but does the secondary party actually have to know that the crime will be committed, as this passage suggests, or is something less sufficient? There's then reference to Lord Simon in Lynch, which we do have in the authorities. Lord Simon in Lynch cited Mr. Justice Devlin, as the M was in National Coal Board Gamble, and continued, the act of supply must be voluntary in the sense I tried to define earlier in this speech, and it must be foreseen that the instrument or other object of service supplied will probably or possibly and desirably be used for the commission of a crime. And then paragraph 49, these words were uttered in respect of a person participating at the time of the commission of the offence by the actual perpetrator. However, in the context of a person charged as an accessory who has rendered assistance prior to the commission of the crime by the perpetrator, the circumstances in respect of which knowledge is sufficient for liability may go wider than that of the specific crime actually committed. This is because, as pointed out in Blackstone, it is inappropriate and unworkable to require knowledge of the essential matters constituting the offence in a situation where the offence is yet to be committed in the future, the point that was ventilated yesterday, or by a person whose precise intentions the accused cannot be certain in advance. It is thus sufficient for the accused to have knowledge of the type of crime in contemplation. Thus, where a person supplies equipment to be used in the course of committing an offence of a particular type, he's guilty of aiding and abetting the commission of any such offence committed by the person to whom he supplies the equipment, providing that he knows the purpose to which the equipment is to be put, or realises that there is a real possibility that it will be used for that purpose, and the equipment is actually used for that purpose. And there's reference to a case called Bullock and Bainbridge. The court then says we turn to Ruddock. Now, my lords, I should point out that at paragraph 53, dealing with the judgment of Lord Justice Lloyd in that case, we see the court disagreed and approved the direction. Lloyd LJ relied firstly on two decisions in the Privy Council which have subsequently been considered by the House of Lords in R, Powell and English. He said, we cannot accept that argument. It's now well established that in a case of joint enterprise, where the parties are both present at the scene of the crime, it's necessary for the prosecution to show that the secondary party intended the victim to be killed or to suffer serious injury. It is enough that he should have foreseen the event as a real or substantial risk, and reference to the cases, some of which we have been looking at. And then the next paragraph, we see no reason why the same reasoning should not apply in the case of a secondary party who lends assistance or encouragement before the commission of the crime. My lords, then over the page at paragraph 56, we see reference to Maxwell and again the passage that was set out earlier. Lord Scarman in the House of Lords approving Lord Lowry's formulation. The principle thus formulated has great merit, and so on, which I read to you.
Yes.
Paragraph 58, Rooke is in our view authority for the proposition it's not necessary to show that the secondary party intended the commission of the principal offence, and that it's sufficient if the secondary party, at the time of his actions, relied on lending assistance or encouragement, contemplates the commission of the offence, that is, knows that it will be committed, knows that it will be committed, or realises that it is a real possibility that it will be committed. So, my lords, the language in Rooke that we have been looking at effectively in the context of parasitic accessory liability. My lords, I can then, I think, go to paragraph 71 on page 1500.
Yes.
We're of the view that outside the Powell and English situation, violence beyond the level anticipated in the course of a joint criminal enterprise, where a defendant D is charged as a secondary party to an offence committed by P in reliance on acts which have assisted steps taken by P in the preliminary stages of a crime later committed by P in the absence of D, it is necessary for the Crown to prove intentional assistance by D in the sense of an intention to assist, not to hinder or obstruct, P in acts which D knows are steps taken by P towards the commission of the offence. Then just dropping a couple of lines, thus the prosecution must prove A, an act done by D which in fact assisted the later commission of the offence, B, that D did the act deliberately realising it was capable of assisting the offence, C, that D at the time of doing the act contemplated the commission of the offence by A, i.e. he foresaw it as a real or substantial risk or a real possibility, and finally, D, when doing the act, intended to assist A in what he was doing. Now, my lords, notwithstanding paragraph 2.64 of the Law Commission's report, to the effect that it might be thought that D must know or believe that P will commit the conduct element, it's clear that basic accessory liability does not, nor could it, require such knowledge. My lords, the purpose of looking at these cases from which I'm going to move on, if not tonight, tomorrow morning, is really this. First of all, it demonstrates, with respect, that that which Miss Geary contends for is asking far too much. Knew that D would. Secondly, it demonstrates that contemplation forms a part of basic accessory liability and has done since 1959, expanded in Maxwell, Bryce being an example of the modern formulation. Thirdly, we saw that Lord Lloyd, at any rate, was of the view that there was no reason why the reasoning in Chang Wing Siu should not be transferred across. But finally, what it also perhaps reveals is that if your lordships are to depart from Chang Wing Siu, there may be wider reaching implications, including for the law of basic accessory liability. So, my lords, in conclusion on this aspect of the matter, therefore, Category 3, or parasitic accessory liability, is not, in my submission, any sort of aberration or tangent, and nor is it out of kilter with basic accessory liability. And my lords, perhaps tomorrow I will go on to make several further submissions, including, I hope, making good the proposition that Category 3, or parasitic accessory liability, is coherent principle and can be justified, which is really only enlarging on some of what I said already in dealing with the test, and then make brief further submissions in relation to one particular matter which concerns statute law in Jamaica regarding sentencing for murder, where they have quite recently in 2005 categorised murder for the purposes of sentencing and the possible implications of any judgment changing the law on that. I will also very briefly say something about policy and with some temerity suggest that this is a matter best left for Parliament. My Lords, unless I can insist further tonight, that is probably a sensible point to stop.
You're happy to stop now?
I am, my Lord, and I feel quite confident I can do the rest in my half an hour, I think it is tomorrow. An hour.
Actually,
well,
I don't want to encourage you.
I feel completely confident, my Lord, in that case.
You don't have to feel you have to take it all up, but you do have
No, my Lord, I won't take that as an invitation to use the full hour. I hope to finish sooner than that.
Very kind. Thank you very much indeed. Well, we will adjourn now, and we'll resume again at 10:30 tomorrow. Thank you. Court's now adjourned.